Hitbullseye, and in today's video, we shall be discussing the important court judgments from January 1st to 15th of 2023. So, let's get right ahead into the video. First judgment is Indian Medical Pharmaceutical Corporation versus Kerala Ayurvedic Company Corporation Cooperative Society Limited. In this particular judgment, basically the Supreme Court, that is CJ DY Chandrachud and Justice Hima Kohli, discussed about the topic of bid or tender processes. So essentially what happens in our country is all the e-procurement or all the government procurement system is done through bid process management or giving out tenders. So when the government has to get into a contract with any private party in order for to do some PPP or in order to procure some material, etc. What it does is essentially it gives out a notification or it gives out a tender, and everybody is required to participate in the tender. Whoever gives the best bid to the government is the one that the party that wins, and the contract is given to that particular party. Now, Justice CJ DY Chandrachud, highlighting this, stated that there are dual benefits of this whole bid process system. Firstly, procurement can be made to the best price. And secondly, allocation is through a transparent process. However, if the purpose of allocation by the state is not revenue maximization, the state could award the contracts through other methods also, but that is going to be arbitrary. So essentially, if we discuss about the facts of the case, what happened was that the UP government was under the process of under the scheme of Ayush scheme. They had to procure some Ayurvedic medicines from any private party. These medicines were to be forwarded free of cost or at highly subsidized rates to the people, to the public who was availing the benefits of the Ayush scheme. Now, in order to procure these medicines, these equipments, etc., what the UP government did was it did not go through the process of bid management, or it did not go through the process of tenders, and it gave the project to Indian Medicines Pharmaceuticals right off the bat. In this, Kerala Ayurvedic Cooperative Society challenged this contract, stating that everybody should have an equal opportunity in order to participate in the government contracts. It further stated that if this right is taken away from the people, then it contravenes Article 14 of the Constitution, firstly, and secondly, it is a wholly arbitrary process. In this case, the Supreme Court bench held that the Kerala Ayurvedic Cooperative Society was in fact correct, and it also discussed about one concept called the social largesse. Social largesse is basically uh, the the basically generous donations that are given by the government. So more so in a welfare society, there are a lot of benefits that are given by the government itself. However, when we consider when we consider that there is a dual role, there's a conflation between powers and duties of the government, then we cannot say that everything that the government is giving, even the contracts, even the economic policies and the economic benefits, are by the way of the social largesse of the government only. We have to consider the fact that not if we consider the social largesse to be coming in the ambit of social benefit schemes and licenses and social contracts and economic contracts, etc., if we consider everything that is given to the government to the people as a part of charity, then that is belittling the concept of social contracts as such. And that is why it was held by the bench that it is essential that unless there are no emergency circumstances. For example, if there were COVID circumstances, and for example, there is a hospital that requires immediately some material to be bought by the government, and there's no time for bidding of that material, then in that case, the government can give its projects to particular people without having to go through the process of bidding. However, if it is not any such case, then the government has to be fair in giving tenders to private parties. In our next judgment, we shall be discussing Kotak Mahindra Bank Limited versus Girner Corrugators Private Limited. Now, in this case, the Supreme Court stated if the legislature confers the later act enactment with a non-obstant clause, it means that the legislature wanted subsequent or later enactment to prevail. Now, first of all, in order to understand this judgment, we need to find out what is a non-obstant clause. A non-obstant clause is essentially a clause that is given with, for example, there is one clause that is given in the uh, there is one clause that is given in the legislature. Sometimes if we can see, there is a provision that is attached to it, starting with something like notwithstanding, or without prejudice to, or subject to something, and succeeding by the other thing, whatever it is subjected to. Now, in this particular case, what happens is that notwithstanding means that notwithstanding the provisions of the whatever is written below, or without prejudice to whatever is written below, as in whatever is written below should not be affected by the above provisions. So we shall consider, so this is basically very important for consideration while we're interpreting the statutes. Here, when we were interpreting the statutes, it kind of clears the mind of it kind of tells the legislative intention as to what the legislature wanted as its priority. Now, this will be more clear if we see the particular clauses that were in question in this particular case. Firstly, there were two clauses. One clause was under the MSMED Act of 2006, and the second was SURFACE Act. Now, MSMED Act was for realization. Basically, MSMED Act sections 15 to 23 stated that the dues of MSMEDs have to be cleared off, but there was no priority given as such that this debt has to be cleared off before, or this has to be done later, anything like that. It was just mere statements. However, if we consider the SURFACE Act is basically the securitization and reconstruction of assets, and it is the act through which the banks get back their loans. So, in this particular act, an amendment was added qua section 26E by the amendment of 2016. The amendment of 2016 stated that it stated notwithstanding anything inconsistent therein contained in the any other law for the time being in force, after the registration of security interest, the debts due to any secured creditor shall be paid in priority over other debts, and all the revenue taxes and cesses and other rates payable to the central government or state government authorities. So basically, in this particular case, it held that all the secured creditors are going to be paid first, and also it is a non obstant clause. Here, it was stated by the Supreme Court that we can clearly discern what was the intention of the government, or what was the intention of the legislature at the time of making this amendment. Essentially, was that this particular clause have to be prioritized over the other clause. So that is why this has to be read before the MSMED, regardless of whether MSMED came first, was enacted first, or was enforced first or not. In this particular case, the Supreme Court also stated that this is a method of interpretation of statutes, and it clarified that when there is a special legislation, so this is a special legislation, even though SURFACI Act was enacted much before the MSMED, however, it is a kind of a special legislation, and therefore it takes priority over MSMED anyway. In the next case, that is Association of Old Settlers of Sikkim versus Union of India. This is a very important judgment. This is given by Justices M.R. Shah and B.V. Nagaratna. Now, in this judgment, the judges stated that women is not chattel, has her identity of her own. Marriage won't take away her identity. The impugned section in this particular case was Section 10 of the Income Tax Act. Section 10 of the Income Tax Act talked about the total income, or how the total income is going to be calculated. Under Section 26 clause, under Section 10 clause 26 triple A, there were certain exemptions that have been given. That is, your total income will not be considered to be total income for certain specific purposes. In that, there is one specific clause. There is one specific clause that, in the case of being anybody from Sikkim, in the case where the produce is where certain thing is produced in Sikkim, or any income originating in Sikkim will be exempted from the total income. However, there was a proviso to it, proviso stating in case of an individual being a Sikkimese, any income which accrues or arises to him, and secondly, there is an exemption if that person is a Sikkimese woman who got married after 1st of April 2008, then her income will again be included in general in the total income. So, meaning to say, summing it up, all the income of the Sikkimese men, all of them, and the income of the Sikkimese unmarried women will be unmarried women, and the women who married Sikkimese men only will be excluded from the total income, and only the women who got married after 2008 to somebody who was not a Sikkimese person, their total income will be included in the total income. So, this provision was challenged by the Sikkimese Women Old Settler Society in the Supreme Court, stating that this was absolutely discriminatory and it was contravening Article 14 of the Constitution of the country. In this case, the Justices M.R. Shah and B.V. Nagaratna categorically stated that it is indeed contravening Article 14, as it is, first of all, it is creating a gender discrimination, that Sikkimese women don't have the same right as Sikkimese men do. They can Sikkimese men can get married regardless of any consequences of this provision, and Sikkimese women, this provision is going to apply. Firstly, secondly, there was a class legislation or an unreasonable legislation or classification on the basis of the date, that was 1st April 2008, as the provision only applied to the women who got married after that age. If we talk about the provision per se, the provision basically, Sikkim was a protectorate, or it became a protectorate of India in 1950s, and in 1975, citizenship was awarded to the Sikkimese people. Indian citizenship rather was awarded to Sikkimese people. So, in order to give Sikkimese people certain autonomy, this provision was added that the Sikkimese income is going to be exempted from the income. However, if the Sikkimese woman gets married to a non-Sikkimese person, then this provision is not going to apply. Now, even this provision has been held to be discriminatory and thus unconstitutional and has been struck down by the Supreme Court. In our next case, let us discuss Pappu Bavaria and another versus District Collector, Civil Station and others. This is a judgment that is given by Justice V.G. Arun. In this particular case, uh, Justice stated that children helping parents in selling articles not child labor. It is a judgment by the Kerala High Court. So essentially, what happened in this case was there were two children who were brothers, who were found selling pens and bangles and other such articles on the Marine Drive in Mumbai. They were taken by the police, and the parents of the children were admonished for not giving them proper education, and they were admonished for making their children sell articles on the street. The children were subsequently taken away from the parents and they were sent to a shelter home in Delhi. They were produced to the Child Welfare Committee, which is constituted under the Justice Juvenile Act of 2015, and the Child Welfare Committee took the decision that it is not reasonable for the children, or it is for the betterment of the children, to stay away from the parents and to stay rather in a shelter home. So, for about 1 year, the children had been languishing in the shelter home itself. Here, the Kerala High Court took the decision eventually that it is being poor is not a crime. So essentially, a lot of children of poor parents are forced into some kind of labor. For example, sitting at the shops for and selling articles, etc. And that does not constitute a crime per se. So, what the Kerala High Court stated was best interest principle. According to the best interest principle, the child, whatever has to be done, whatever decision has to be taken, has to be in the best interest of the child. The best interest of the child is not only that he gets the maximum education and he gets the maximum monetarily. He gets the best monetary benefits. However, it is also to stay with his biological family and to be able to stay with his siblings as well as parents. So, in this case, quoting the father of the nation, quoting the father of the nation, Justice V.G. Arun stated that poverty is basically the most violent thing against people, and therefore he stated, no doubt children ought to be educated rather than being allowed to loiter on streets along with their parents. I wonder as to how the children can be provided proper education while their parents are leading a nomadic life. Even then, the police or the CWC cannot take the children from the custody of the parents and keep them away from their parents. To be poor is not a crime, and to quote the father of the nation, poverty is the worst form of violence. So they restored the custody of the children to the parents again. And this is, yes. In our next case, and the last case, I believe, all conversions can't be said to be illegal. Stating this, the Supreme Court refused to stay the MP High Court order against the declaration before the DM to change religion. So essentially, what happened in this case was this is right now an SLP has been filed in the Supreme Court to analyze the provisions, the constitutional validity of the provisions of this particular act. The act in question is Madhya Pradesh Freedom of Religion Act of 2021. This act was promulgated last year only, And this act essentially states that whoever wants to convert to any other religion has to basically give a 60-day notice to the district magistrate, stating that he wants to firstly convert his religion. Secondly, he is doing it with his own will and volition. And secondly, he is not under the coercion or undue influence or any other kind of influence of somebody else. Secondly, this declaration is to be made by somebody who's changing his religion. And secondly, there is another declaration that is required to be made by the religious clergy of the religion to which that person is converting. So, whoever is performing the conversion exercise shall file an application with the same district magistrate with for before the same period, at least 60 days before such conversion takes place. And if either the convertee or the converter, either of them contravene the provisions of the law, there's a minimum punishment of 3 years with a maximum punishment of 5 years, and he shall also be liable to fine of 50,000 rupees. Now, this particular provision was challenged, and in this very instance, the Supreme Court has first of all stated that there was a previous case in which a very similar clause was interpreted by the Supreme Court. That is in Reverend Stanislaus versus the state of Madhya Pradesh. This is a case of 1977, and in this particular case, it was held that it is perfectly constitutional that such provisions do not basically contravene any provisions of fundamental rights. However, what is to be taken care of is that not all conversions can be said to be illegal. The High Court, basically the stay of the High Court and the opinion of the central government to intervene in all matters of conversion is not true. Illegal conversions or unlawful conversions are only the conversions that are given after the that are given without the consent of the person, or if the person, or if a fraud has been committed on that person or such. So this is all from our end. I hope you found this video informative, and I hope if you have any doubts, you comment below. Please don't forget to like, share, and subscribe the video. Thank you, and see you in the next video.